After 2 weeks, Lordship.
After 2 weeks, all right.
Well, Lordship, I beg to mention item number 15. On this matter, your Lordship, we have to file affidavit. So today, my learned counsel or parties out for station, so the matter may be fixed after 3 weeks.
Correspondent.
2, yes.
You
I'm
are
appealing on behalf of,
Appellant.
yes,
I'm for the revision petitioner. I am appearing.
not appealing, your Lordship, for respondent number 2,
Yes.
Respondent,
2.
respondent number 2.
Yes.
Learned counsel for respondent number 2, Miss
I am Likha.
M. Nikha. With the consent of the learned counsel, with the consent of the other side has prayed for adjournment.
Yes.
This is the matter after 3 weeks.
Well, there's an interim order that may be
Interim order
extended.
shall remain in force till then.
Problem.
May I please? My lord,
Yes.
this item number 11,
11,
can this be taken up on Monday, my lord?
of course.
This is an application filed by the state. my lord.
By the state,
Yes.
appeal, acquittal against acquittal or something else.
It's
All
for the
right.
cancellation of bail.
Ah,
Cancellation of bail.
not hearing.
For the cancellation of bail, my lord.
Oh, cancellation of bail. Oh, sure. List the matter on Monday. What is the date?
Monday would
Monday.
be 24. Bless you.
Kritika is out of station, that much I know. Yes, yes. This is your senior item.
Your lordship, there is a typographical mistakes in the petition, so liberty may be given to file a fresh application, Your Honor. This is a transfer petition. Domestic violence which is pending here in the GMFC court to transfer that matter there in the Teju jurisdiction, Your Lordship. So there is a typographical mistakes in the petition, so liberty may be given
To
to file a
petition.
fresh.
You want to withdraw this?
Yes, yeah, I'm with you.
Current council, Mr.
T Tarin, Tau Tarin.
T.
Ah.
Tarin
Yes.
has prayed for withdrawal
Withdraw.
of the petition due to a typographical error in the petition.
Petition,
Prayer for withdrawal, with liberty to file a fresh
fresh,
petition.
yes, you are-
Correct?
yes. Apply.
Matter is closed, huh?
May please, your lordship.
Hmm.
Lordship, this is 227 application. And we are selling an order by which in a during the pendency of an appeal, your honor, the execution petition was disposed of. We could not move before the appellate court because there is no chairman in the state commission. So during the pendency of the appeal, your honor, my lord, the execution petition was disposed of. My lord, may kindly come to page 52. Page 52. The impugn order, your honor, my lord. Page 52, my lord. This is order dated, my lord, 36/2023. Mr. So and so counsel for the petitioner, so and so counsel for the judgment debtor. We were for the judgment debtor there. Mr. So and so has vehemently and verbally argued that instant execution is beyond limitation, prayed for dismissal. His submission is not accepted, having regard to the rules laid down by so and so and so and so. The respondent is directed to deposit so and so, including interest amount within 1 month from today. With the above order, this case stands disposed of. And this order was passed on, my lord, on 36/2023. And we have filed, my lord will kindly come to page 45. page 45, my lord will kindly see that we have filed against the judgment and order against the debt. We have filed in first appeal under section 15 of the Consumer Protection Act. And during the pendency of the appeal, because there was no commission, we had moved, we have filed stay application also, but we could not move, Your Honor, because there is no president in the state commission. Because of we have faced difficulty and we could not stay the execution proceedings. Your Honor will kindly see that this is the case number 2/23 and application date is 20/6/23.
President is on leave, I believe,
No, Your Honor, president is not there,
not appointed.
not appointed. Although advertisement is done, soon it will be appointed. It within 1 or 2 months, it will be appointed. So our difficulty is there, Your Honor. And execution petition has been disposed of. Our appeal is pending, Your Honor. And Your Honor, the judgment and or decree passed by the trial court was heard in absence of us. It was in ex parte. Your Honor will kindly see. Your Honor may kindly come.
So,
We have a good ground in appeal.
under what provisions have you come? What is this?
Under 227, Your Honor, my lord, 227. Because otherwise,
27, okay.
Your Honor will kindly come to,
I'm not sure, okay. First, your first appellate court is the commission, state commission.
yes, Your Honor, yes, my lord.
227,
Look, under, my lord has supervisory as well as superintending power
then
under below all the courts under below, my lord. And in respect, Your Honor, my lord, we don't have any options at this point of time. So during the pendency of the appeal, Your my lord, the execution petition was disposed of. Then literally our appeal has become infructuous. And Your Honor will kindly appreciate one thing, that
this appeal was pending, but
Yes.
the execution petition was disposed.
yes, disposal.
Appeal was pending, there was no stay order.
There's no stay, but obviously there was no stay
Obviously
order.
Not meant by anybody. now.
Yes, yes, Your Honor. And Your Honor will kindly see, Your Honor, my lord will kindly see that,
So let's do one thing, let's issue notice.
you know, if the stay is, because we are directed to,
I don't know. Let's issue notice because
my lord,
you
I
can- execution proceeding, you can ask for a date.
already disposed of. We-
I know it disposed of, so you have to pay.
Yes,
So where, if you don't pay, then distress warrant will be issued.
yes,
So you can ask for a date for payment.
my lord,
Till then we'll call for the LCR and we hear the other side. I don't know, I'm not very clear about this.
my lord may only appreciate one aspect, my lord.
I'll bring it on record. You take, see, we will call for the LCR and on returnable day, we will consider the matter of stay. I'll bring it on record in the order.
My lord, my lord, for a moment, my lord, my lord, may I?
See, when I'm not clear about the.
Because, my lord, under 227, my lord, we can file, my lord. This is not the first time, this won't be the last time also. 227, my lord has the power, that I am very sure about it. Only that aspect, my lord, why I am urging before this honorable court is that, lord, if this is not done, we are supposed to
I'm
file.
giving you a very short date. Let us issue notice. I'm giving you a very. short-
Because my lord, 30 days, within 30 days period, when 1 month period.
This case is pending at which stage? I'll give you a very short date. You won't suffer. I'll give you a very short date. Pending also, this is at the motion stage. So let us issue notice and regarding the stay of the execution matter, execution is disposed
Is
of.
disposed of.
So regarding payment, so you have to pay. So.
Because your, my lord will,
We'll consider a suspension of sentence.
my lord,
What is your prayer? Suspension of sentence?
yes, my lord. Because, my lord, if the other side comes, my lord,
On
then
the next date, on returnable date. On it, I will give you a short date on returnable. What is your prayer?
my lord, in the interim state the operation of the impugned order passed in so and so. Because, my lord, it will be obvious,
We'll
it,
consider on the next date.
my lord, I'm urging, my lord, sorry, I'm sorry for that, my lord. Because, my lord, if this is not stayed, then this will be end by this month, because 1 month period is only there. So, because this will subject to the outcome of the CRP, obviously this will be subject to the outcome of CRP. If I succeed, then obviously the stay of, then I will be saved. But if I'm not,
All right. Just a moment. Where are your relevant points
yes,
in
ma'am.
the petition?
11 points, your honor, my lord will find it. Grounds, my lord, you'll find it page 7, my lord,
Page 7.
page 7 of my CRV. And page 8 is page 8, paragraph number 6.
So there has been delay also.
Yes, your honor, there is a delay. We have filed delay application also.
Where is the delay application?
We have not annexed it, but we have filed it.
In the appellate court.
Yes, appellate court. There is a stay application also, there is a delay application also. Will not give us a chance, my lord. Only I am praying for a chance to urge our case. We have an appeal pending. And it was heard in our absence.
What is this?
This is the part of the appeal. This is the delay application, my lord. Delay is yet to be registered, but the appeal has been registered. Appeal is registered as 2/23.
So who are the respondents here?
One respondent, my lord. Only one respondent is there.
So that he's a private party.
Yes, private party.
So why are you not paying? There is an order in the court. Why are you not paying?
My lord, appeal is on, this will be decided on merit. Appeal, in the appeal, my lord, we were not represented by the council. So we could not argue or we cannot submit our case in the appeal, in the trial court.
Ground in the petition.
Yes, sir.
So I have read the ground number on paragraph 7 and 8. Then regarding that you are not non-represented.
Yes, 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 ma'am. My lord, in the, my lord, may I kindly come to the appeal memo, my lord, at page 45. Page 45, if my lord comes to.
No. Ground in this present petition.
Present petition, I have not, my lord, because our grievance of not getting a stay or not appeal being heard is only that because state commission is not there.
Right. Appeal memo at page 45.
At page
Which
45.
Page.
Page 45, my lord will kindly see. Page 46, if my lord comes to. Paragraph 5.
Page 46, paragraph 5. Page 46 has
Page-
this paragraph 5.
Page 46, para means fifth. Page 46, if my lord comes to. Page 46.
I think 47.
47 is also there, my lord.
But there's no paragraph 5 in page 46.
My lord, this. Because this is a ground in the appeal.
You read out.
Yes. For that, the learned district
This
forum.
is in page 47.
Oh, yeah, my lord. Sorry, my lord. I'm sorry for that. For that, the learned district forum, due to the absence of the appellant opposite, but did not discuss the statement in contention of appellant herein to the complainant filed by the respondent herein, delivering the judgment in order. Indeed, view the judgment impugn is untenable and liable to be interfered with. And
No, you have not written that you are not represented.
my lord, there is. My lord, at page 48 and paragraph 9. For the impugn order is hit by the well-founded settled principle law that for a council's mistake, the party should not suffer. At
Where is the judgment? Where is the judgment?
judgment, my lord will find at page 27, and there it is reflected, my lord.
No, for the, this is para 9, for the appellant opposite party number 1 cannot be held responsible for an employee.
Yes,
So you have not written that you are not represented.
my lord, there is para 9, para ground 9. for that the impugned judgment is hit by the well-founded and settled principle law that for a council's mistake, the party should not suffer. In the instance case, the learned counsel representing the opposite party appellant did not turn up before the learned district forum on the date of the hearing to put forward the case of the opposite party appellant herein. As such, the learned forum below has failed to take into consideration.
There is 11.
Yes, that is 11 year. Madam. I'm sorry for that. And this has been reflected in the impugned judgment, my lord.
So you see this paragraph is also not complete. Para 11, your paragraph is, you read out few sentences, the
Yes.
sentences are not along with the copy.
My lord, I'm sorry regarding that because,
All right, all right. So what is the judgment? Where is the judgment?
yes. My lord will judgment, my lord will find at page 27. It's 27, do page mein. It starts at page 27. And my lord will kindly come to paragraph 6 of the judgment. Paragraph 6 of the judgment at page 29. During final hearing of the matter, none appeared for the contesting opposite party, but in interest of justice, this commission has given sufficient time to him and even fresh.
Representing that car dealer.
Yes, Cardinal.
So why you not paying the compensation? Why didn't you want to pay the compensation?
Your Honor, my lord will appreciate that the facts or the merits of the case were not discussed. We have sufficient to prove that we are not liable. The person who is missing, he is liable. And he has done in his own capacity. We are not vicariously liable also for that matter. And that will be decided in the appeal, my lord, with all respect, my lord. Because appeal is pending, we have filed appeal. Appeal will be decided on merit. Whether we win in the appeal or we lose, that is another aspect. But at least we should be given a chance, my lord, at least. No, till the returnable date, at least, my lord, let the opposite party comes, my lord, till the returnable date, impugned may be suspended. Otherwise, my lord, we don't have a case at all. Because by today's 19, so by this month it will be done.
So this you have not appended with the record.
Yes, ma'am.
So I will not go through this.
Yes,
Whatever I have, I'll
Yes.
see if I can pass an order in the favor.
yes, ma'am.
Mr.
NBP Singhal.
NBP Sinha, Learned Counsel for the petitioner, MSITA 4. The petitioner has filed an application under section 227 of the Constitution of India, challenging the judgment and order dated. No, you're not challenging the judgment and
No,
order.
we are only challenging the impugned. That is before the appellate court.
You're challenging this order
30.
at page number 51.
Yes, ma'am.
Challenging the order dated 36,
Madam.
2023, passed by the President, Consumer Dispute Redressal Commission, Papumpare, Arunachal Pradesh stop. Stop name, whereby the petitioner was directed, petitioner stroke respondent was directed to deposit rupees 6,40,000 including interest amount within 1 month from 30/6/2023. An appeal was preferred by the petitioner before the State Consumer Disputes Redressal Forum. It will be commissioned now, no?
Yes. Commission.
Commission. State Consumer Disputes Redressal Commission, now at present.
Yes.
Capital Complex at UP and Arunachal Pradesh. Under Section 15 of the Consumer Protection Act 1986. Against the impugned ex parte judgment and order dated 28/10/2022 passed by the President of the Consumer Dispute Redressal Commission, Pakumpade. During the pendency of the appeal, the impugned order dated 30/6/2023 was passed. It is submitted that the President of the State Consumer Disputes Redressal Forum has not been appointed as yet. And so the appeal was pending and the order dated 30/6/2023 was passed. The petitioner is highly aggrieved by the order dated 30/6/2023, but he could not approach the proper forum against the impugned order dated 30/6/2023, and the consumer had to prefer this application under Section 227 of the Constitution of India. Along with the statutory appeal against the judgment and order dated 28/12/2022 in consumer complaint case number 02/20, the petitioner has also filed 2 misapplications for stay of the impugned judgment and order dated 28/11/22 for coordination of delay in filing the appeal. Due to the absence of the, not president, chairman.
Chairman, President,
Where you wrote president, you just strike out president and write
Chairman,
chairman. So chairman,
Chairman.
due to the absence of the chairman in the state commission, no order for stay of execution proceedings could be passed and the consumer and the petitioner will be, and the petitioner has been highly aggrieved by the order dated 30/6/2023 of the execution petition number 1/23, which was passed without hearing the petitioner.
We were heard, but in the earlier, yes, we are not heard. We were absent. We were.
But this order, you heard in this order, but
Yes,
not in the
no,
judgment.
not in the judgment.
You strike out the last part, which was heard without hearing the petitioner, strike out this part. It is contended that the petitioner was not heard when, and the judgment and order, and the impugned judgment and order dated
28,
28/10/22
10/22.
was passed by the district commission without hearing the petitioner. So it is submitted that the petitioner has a case. And if he is not heard, even at the appellate stage, he will be highly prejudiced. Considering the submission of the petition, petitioner, the operation of the order dated 36/2023 is stayed until the returnable date.
Yes, Miller.
If you notice to the respondent to register post
Yes,
with AD, returnable within 4 weeks.
Yes,
Call for the LCR,
yes,
or should I call for the scan copies of the LCR?
Miller may call for the scan copies also, Miller may call for the records also.
Because
Either way,
maybe, if somebody may like to.
Yes,
vacate the stay order.
will-
So call for the scan copies of the LCR of both the proceedings.
Yes.
Including the execution proceedings.
deeply, Miller.
This is the matter of the 4 weeks.
Miller, may I take the liberty to correct certain things, Miller? Some pages are missing, so may I take the liberty to correct that? That page, Miller, that was missing.
I think now there's a notification has been issued regarding amending the.
Miller, I will amend, Miller.
Filing amendment,
Miller,
maybe.
Miller. Oblige, Miller,
I
deeply.
think you've gone through the notification.
Yes, Miller. Miller, deeply,
Have to file everything in amendment.
Yes, deeply.
Certain page, not the last part, not required to be corrected, there are only 2 lines, not required. And there are wrong numberings of pages, not required. One number, you just add 1 number when you submit.
Miller, actually, Miller, I have also come down today from Guwahati, so it was a little bit in a hurry.
You just add 1 number, if it is page 46, you add page 47.
Yes. Oblige, deeply.
My lord, this is a bail application.
Bill application,
Yes, Your Honor. Yeah,
Yeah.
yes, my lord.
motion stage,
Yes.
section,
354 IPC read with section 8 of
how
Boxer.
long it's been in jail?
For quashing the FIR number 2 of 2023 under section 456, 354 and 323 of the Indian Penal Code. 456 is lurking, trespass and housebreaking at night. For which punishment is 3 years. 354 is criminal force for outraging modesty of women, which is for 2 years. And 323 is hurt.
3 years, 2 years,
And 1 year. Hurt, that is for causing hurt, 323, that is for 1 year. So the punishments are of 3 years.
so
and
this
below.
case is pending at which stage?
This, only the FIR was registered by the parties due to misunderstanding that was caused. And they've executed a settlement agreement, which is at page number 16. After which, the settlement also was done on the same day of lodging of FIR. Hence, the matter has not even been charge sheeted yet.
Still under the stage of investigation.
Yes, Your Honor. If I may read the FIR, Your Honor.
Yes,
If I may read the FIR,
course.
it is at page number 14, annexure 1, and 15 is the type out copy. I am to inform you that yesterday night, about 1:30 hours, that is early morning on 5/7/23, one unknown person trespassed in my dwelling house and he attempted to rape me. When I woke up I immediately hit on his chest for self-defense, and he ran away with one bundle of key left behind from him. After a few minutes, our Gaugura came and tried to open my dwelling house door, and he requested me for release of his key, which was left by him during attempt to rape, but I denied and kept his key in my custody. The key is being produced before you for further necessary action, please, as per provision of law against above mentioned person. Your Honor, the submission of the petitioners herein is that the petitioner, both the petitioners, accused and the informant, are known to each other. And the accused person had attended a party in the house of social gathering in the house of the informant on the previous night. And he had left his key behind when he was in the house of the informant. And the case that is stated in the FIR, according to
what
the,
about the LCR? What do you say?
Well, this matter is in the stage of investigation. Since the FIR was filed on 5/7/2023, and from the record, it appears that the same settlement agreement was also
Yes.
done on the same day.
They will settle, maybe.
That's the reason,
it's
my lord,
been
the
quashed, but let us.
timing
let
of the
CD,
settlement
let's call for the CD,
can be done.
investigation won't progress also.
okay, Your Honor.
That's
But the
what
matter
I'm
was settled on the same day itself. And
But
the,
see that allegation in the FIR,
but she says unknown person.
Case
And then-
may have not been registered with 376 by 511, but the allegation is,
Because Your Honor, even in the FIR, it's not clearly mentioned, the accused person has not been named for the
at
theft.
the
Just
motion
because,
stage, it is difficult, but after a proper
No.
hearing, it can be quashed.
okay, Your Honor.
At motion stage, because the allegation in the FIR, only because of the allegation. Sections are okay, that will quash, but allegations in the FIR. We'll call for the CD, as it is the question we state. Hard Miss
T.Y. Bhutia.
T.Y. Bhutia, learned counsel for the petitioners. Petitioners number 1 and 2, who have jointly filed an application under section 482 CRPC. We declare for quashing and setting aside the FIR dated 5/7/2023 in connection with Balemu PS case number so and so under so and so sections. Heard Mr. J. Sering, learned public prosecutor for the state of Arunachal Pradesh. The learned public prosecutor has accepted notice on behalf of the respondent. So no formal notice is required to be issued to the respondent. Call for the CD,
Yes.
list the matter on
After 2 weeks.
after the 2 weeks. Final. Just add one more line. It is also submitted on behalf of the petitioner that on the same day of lodging the FIR, the petitioner the petitioners have amicably settled the dispute.
May I please, petition Lordship. Lordship, this is joint petition filed by the victim and the accused person on the strength of mutual settlement agreement.
Item number,
Item number 3,
husband and wife.
not husband and wife. Friends, close friends. Lordship, this matter has been
323.
pending before.
Arms act is also there.
Oh, I'm sorry.
Arms act is totally not attractive, Lordship. Not
Yes.
attracted, not attracted,
I'm sorry,
Yes.
it's not rejected.
attracted.
He had a gun with him.
Yes,
Where is the FIR?
FIR is at page 15.
Page 15.
Yes. Mary Rose. With due respect, the undersigned would like to inform you that early morning at 4:30 hours, information received from Control Officer Itanagar that control received from a person introducing himself as Takpor Yamuk that he was arguing and quarreling with one Jarod Mara, an official residence of Sri Punji Mara at ESS sector Itanagar. Upon receiving the information, the undersigned being ICPR along with Siti Kejilan and Bogom Ketchak rushed to the spot. On reaching the spot, it was learned that while tussling Jarod Mara, so and so of village so and presently residing at ES.
What is
sector.
this city K Gillen? Is it the title? City,
Sorry, Your Lordship.
city, is it a
This-
title? City K Gillen?
There's constable.
Constable.
Constable, so he was having that gun.
Actually, he was use his personal gun perhaps, Zero Mara, Your Lordship.
Or the other person?
The other person, yes.
License gun.
Yes,
License gun.
but it's violated the condition, Your Lordship. The arms act is not only confined to the license. If condition is valid also, Your Lordship, the arms act is attracted, Your Lordship. Here he has violated the condition.
Motion stage, it is difficult. Let us call for the
So,
motion stage. it
this
is-
is not motion, is Lordship. This
Admission,
matter is
Your
pending for the last 7 months.
Oh,
Only on,
motion stage.
yes.
Did we receive any LCR ending?
Scan copy is already there.
So this is at the stage of hearing,
Hearing on.
admission.
Admission, Your Lordship.
Okay.
The matter will be disposed of today.
Can we dispose of today?
Dispose of, Your Lordship, in the light of the Lakshmi Narayan case, Your Lordship, since the arms act is there and no doubt, Your Lordship, in arms act cases, basically your court see whether there is a license, he is possessing the license or not, but in most of the time, Your Lord, we forget their conditions are also there under arms act, under what condition you have to carry the this arm, what act you shouldn't done, what you cannot done. So here in
There
this
is
case,
guideline in the
yes, Your Lordship, the arms act cannot be quashed as per the Lakshmi Narayan guidelines, Your Lordship.
And so far as the present case is concerned, no doubt the person is possessing the license, but he has violated the condition of the arms act, your lordship.
Also, there is catena judgments wherein it is clearly stated that section 27 clause 1 will not attract when it is the license are.
I'm not
Right.
on section 27, on section 30 is there, your lordship.
Section 30 is trivial offense. Lordship. Lordship will find it with para 28. Page 15.
This is not 482 petition.
No, Lordship, it is clear in
This will not work. This is not 482 petition. This is a appeal against conviction.
herein it is clearly stated 27 section 27 of Arms Act is not attracted when the gun in question is licensed.
Then we'll have to go for a proper hearing.
And moreover, similarly
We'll
situated
admit
case.
it then, we'll go
No,
for a
if
proper
Lordship is
hearing.
not satisfied with that, I can,
If you have 482.
yeah, this is for
any
it.
judgment regarding
Yes,
482 CR.
this is the judgment of honorable, this one honorable High Court only. Wherein arms similarly situated case,
Hmm?
similarly situated case wherein it was quashed. Invoking,
coordinate bench.
yes. Invoking the judgment of Narendra Singh.
Which paragraph? This tying Anthony and another versus state of AP.
Yes,
This judgment, which
Yes.
paragraph? He had a gun. Did you give him a copy?
no, I will.
It's okay, your lordship.
So.
This paragraph, in this judgment, there is no exactly
Judgment, I'll count the paragraphs.
Lordship, in para 4, in pursuance of the investigation of charge sheet, so file charge sheet will frame under section so and so 427.506, read with section 27 clause of Arms Act.
Yes.
And this matter was quashed by this honorable court.
So do you have a deed of agreement?
Yes, deed of agreement is there.
Your lordship, the submission is making on the percent to section 27 only, your lordship. Section 30 is also there. Your lordship may kindly come to the your lordship, arms act, your lordship, section 30, your lordship.
There's an RBF.
Lordship,
Here is the arms act.
section 30 is very trivial offense also. Trivial offense,
Section 30.
section 30. It's all,
Your lordship,
its punishment only for 6 months or fine.
that doesn't matter, the punishment of the arms act, your lordship. The all are serious of it. It's a statutory act, your lordship. And I will, your lordship, rely on the Lakshmi Narayan case as well, your lordship.
Lordship, the FIR was filed on December 2022, and the matter is still not charge sheeted, meaning there is no case at all.
December 2022.
2022. This is case of 2022 and still no charge sheet, meaning there is no, this is the case where two friends.
Arms Act takes some time.
Sanction is required.
Punishment for contravention of license.
Yes, your lordship. The gun is required to be kept here. This is the, your lordship, the punishment for rule, condition of license, your lordship. So it says, as per this provision, it clearly says, it meaning thereby, the person even having a license, he cannot contravene the rule, your lordship. He has violated the rule in this case, your lordship. So this is the, no doubt, so far as section 27 is concerned.
This person in this Anthony's case.
Yes, your lordship.
By the coordinate bench judgment.
Yes, your lordship.
No. You'll have to submit with the petition
The petition I have enclosed.
and close.
Yes.
Or
It's
this
the
is
old-
not required then.
Your lordship may, I would like to rely the Lakshmi Narayan case, your lordship.
So we have a judgment of this court also.
But Supreme Court judgment will prevail, your lordship. The coordinate bench may have the respectful, your lordship, dissent with the view finding of the learned court, coordinate bench, and the fact and circumstance also matter, your lordship.
More or less similar.
Lordship may, your lordship may kindly come to para 13.
Page.
Para 13, your page 10, your lordship.
Which part?
Your lordship, para 13 is the parameter. And
That I have read several times, but.
and 4, I will read only 4, your lordship.
Huh?
Is regard only 4,
Four,
surplus 4, your lordship.
Yes.
Opens under section 307 and the Arms Act, etc. It clearly says Arms Act. It doesn't categorize any sections of the Arms Act. It clearly says Arms Act would fall in category of heinous and serious offense and therefore are to be treated as crime against the society and not against the individual alone. And therefore the criminal proceeding for the offense under 307 and or the Arms Act, etc., which have a serious impact on the society and cannot be quashed in exercise of power under section 482 of the code on the ground that the parties have resolved their entire dispute amongst themselves. However, the High Court would not rest in its
This is
decision.
only regarding 307.
307 and Arms Act also, your lordship.
That hurdle is only on that, scruple is only on the arms act,
Yes, your lordship.
but on 307.
Here, your lord, 307,
there
what
is a relaxation.
it was Supreme Court says, your lordship.
There is some
Sometimes
relaxation.
there may a situation where the section is just for corporate
The
court in.
relaxation is not regarding to arms act.
Yes, your lordship. The
So this judgment is against you. So this coordinate bench judgment is in his favor and the judgment is, let us admit it, let us admit it. We'll take a proper hearing,
yes, your lordship.
cannot be disposed of at this stage.
This hurdle has to be overcome, your lordship. The Supreme Court judgment, your lordship. It on the fact on circumstances, no doubt, your lordship.
Now, he has a judgment in his favor.
Yes,
You
your
have a
lordship.
judgment in your favor.
But the only problem here is, your lordship, the section 30 is also there, the violation of rule. Section
Yes,
27.
Yes, yes.
27, no doubt, your lordship, license is there, it will not attract it, no doubt, but 30 will remain intact, your lordship, and for that,
A proper hearing is required that this, he has this case also, appeal against acquittal.
Yes,
There is. Surinder Singh versus State Union Territory, so he has got two cases. in his
Very
favor.
clear
your lordship, that is post conviction, your lordship, that is post conviction, your lordship. Yes, your lordship.
I understand, but that.
In post conviction, your lordship, many things crop up, your lordship,
principles can
evidence,
be
everything, your
applied.
lordship.
I think principles also can be applied.
That
When we
can,
decide the case conclusively, I think principles can be applied, let us admit it,
yes, your lordship.
cannot reject it.
Yes, your lord, it may fix for hearing, your lordship.
Heard, Mr.
M to not.
And M to not, Learned Counsel for the petitioners, Takpo Riamu. And Sri Gerard Mara, who both the petitioners have amicably settled the dispute and they have jointly filed an application under section 482 CRPC with prayer for quashing the FIR, only the FIR. FIR dated 16/12/22 registered as Itanagar PS case number 301/22 under section 336 IPC read with sections 27(1) of the Arms Act. The Learned Counsel for the petitioner has relied on the decision of a coordinate bench of this court in Sri Tying Anthony and another versus State of Arunachal Pradesh, and ये पहले लिखना and अभी जो बोलेगा ये पहले लिखना on the decision of the Honorable Supreme Court in Surinder Singh versus State within bracket Union Territory of Chandigarh bracket close in criminal appeal number 2373 of 2010. Heard Mr. T. Etek, Learned Additional PP for the State of Arunachal Pradesh. The Learned Additional PP has relied on the decision of the Honorable Supreme Court in State of Madhya Pradesh versus Lakshmi Narayan, 2019 within bracket 2 ACR 1230. After considering the submissions at the bar with circumspection, petition is admitted for hearing. This is the petition for hearing on. When do you want?
Short date.
List the matter for hearing on short date.
After 2 weeks.
After 2 weeks.
After 2 weeks.
Fix
I'm
the
keeping
fix.
the judgments in this.
Yes, your lordship. Oblige.
May I please, my lord? My lord, this criminal petitions jointly filed by husband and wife. Petition number 1 is accused person and 2 is a wife. So here in the cases, my lord, that due to some matrimonial dispute between the husband and wife, so they were living separately more than 1 year. So in the rest of that time.
What is this IA for?
IA, IA is that last time the learned trainers submit that since there is a multi-purpose society, Abu Ane multi-purpose society. So allegation is the misuse of sum of rupees 4 lakhs, my lord. Allegation is misusing of rupees 4 lakhs in the name of Abu Ane multi-purpose cooperative society. So on the government side, they have prosecution side, they have made objection that rest of the society members should file affidavits. So based on this, IA is filed, my lord. So IA is filed that, my lord, here the rest of the society members, who is a society of that concerned member, member of that concerned society. So they have given consent letter that they have no objection for quashing of these criminal petitions, because allegation of misuse of rupees 4 lakh has been reimbursed by the accused persons along with the interest thereof, my lord. 4 lakhs, 49,500 has reimbursed accordingly. So matter was almost settled. So based on that, this other member has given consent letter, my lord. So I have included page.
Multi-purpose society.
Yes, my lord. So page number 6 is the consent letter, my lord, in my IA, my lord. So if may I read on, my lord. This is to certify that we are the chairman, general secretary, and shareholders of the NGO called Abu Ane Multipurpose Cooperative Society, headquartered located at Sod Village, POPS, Naharlagan district, Pavampara, Arunachal Pradesh, that we have no any objection for quashing of FIR while Naharlagan PS case number 45/2017 under section 419, 468, 471 IPC between the state of Arunachal Pradesh versus Sri Navam Paryo, who is a petition number 1. As the matter was already settled on dated 6/9/2012-22, and according Sri Navam Paryo has reimbursed rupees 4,49,500 only arising out of FIR dated 13/4/2017 in connection to Naharlagan PS case number 45/2016. Therefore, in our full consent and sound mind, we are giving this consent without any pressure and favor from our end as a members and shareholder of the concerned NGO. So my lord, they have no any objection for quashing. So accordingly, I have reimbursed that amount which I took on the name of NGO. So now matter is that, my lord, my wife has launched FIR. This NGO, my wife is the chairman of this society. So during, we have some dispute, matrimonial dispute. So we living separately more than 1 year. So in duration of that, this society was almost defunct. So I took in charge of chairman, and I'm in the name of society, government has sanctioned 4 lakhs. So I withdrawn that money and I spent in the name of society. But later on, my wife has launched FIR. Accordingly, case was registered against me in Naharlagan police station. So case was registered. So based on that, my lord, we have already settled mutually, and deed of agreement also we have made. It's enclosed in my petition, my lord, page number 81, my lord. Page number 81 is a mutual settlement.
This case is pending at which stage?
My lord, this is an appearance stage.
Yes.
Yes, only appearance and a learned court of
From so
JMFC.
FIR is at page 81
Yes, my lord, this agreement deed of settlement is page number 81, my lord.
and
So
FIR
the-
was lodged on
Laws in 2016, my lord.
2000. So why it is still at the
My lord, because police has,
it's still on the investigation stage?
now it's on, matter is appearance stage, my lord.
Appearance stage.
Yes, my lord. So, my lord, since now we are almost resolved our matrimonial dispute also, and we are living together as a husband and wife, and we have 3 minor child.
So where is the FIR?
My lord, FIR is, my lord, page number 11 to 13, my lord. Page number 11 to 13, my lord, this FIR. FIR is very lengthy, my lord. May I read out?
Yes, yes.
This is to inform you that once Sri Navam Paryo has completely forged the document in connection with Abu Ane Multipurpose Cooperative Society Limited, so as to misguide and mislead the authority concerned for his wrongful financial gain. the state government of Arunachal Pradesh accord sanction sum of rupees 4 lakhs only. The earmark in favor of Abu Ane Multi-Purpose Cooperative Society, white order number so and so, dated Itanagar so and so. 17 February 2016 for the purpose of setting up handloom unit for the year 2015 to 16. However, imposter man, namely Sri Navam Parya, has deceived the authority concerned and wrongful manner withdraw sum of rupees 4 lakhs only, which was meant for Abu Ane Multi-Purpose Cooperative Society Limited. He has cheated the authority concerned on Abu Ane Multi-Purpose Cooperative Society. It is brought into your knowledge that Sri Navam Parya is not even a primary member of Abu Ane Multi-Purpose Cooperative Society Limited. Abu Ane Multi-Purpose Cooperative Society Limited is only registered society under the Arunachal Pradesh Cooperative Society Act 1978. Act so and so. The governing body of the Abu Ane Multi-Purpose
So
Society.
this is under section 419, 460.
Yes, my lord, cheating, perjury, cheating,
This is
perjury.
not a husband-wife case,
No, yes, my lord, because,
but the wife and the husband have jointly filed this petition.
yes, my lord.
So wife is a complainant.
Wife is a complainant, my lord.
So she is mentioning him as he is a stranger, Srimati Nabam Melun.
Navam Melon is my wife, my lord.
She is your
Yes,
wife.
and my lord, we have another case also, and we have also filed criminal petition before this honor, and lordship has crossed the another case.
Oh.
For section 498A was there.
Oh,
So lordship has already crossed
I
that.
have question.
Yes, ma'am. So this is another case, my lord. There was a FIR, counter FIR and FIR, my lord. So almost all matter has been resolved between the parties.
Yeah, Lordship, yes, Lordship, this FIR was lodged by the wife of this petitioner. Lordship, here, Lordship, I was objected earlier, Lordship, because between these two, this here joint petition or is also Lordship, this wife name is reflected and the other members are there, Lordship. So I was asked him to give the concern about the rest of Lordship, rest Lordship.
Now
Now,
he has paid back the money also.
Lordship, it is clear, Lordship now. Now, Lordship, if Lordship is satisfied with this Lordship IA done, then it can be passed Lordship, because Lordship, here everything is settled now, Lordship, and the joint petition also, Lordship, it is expected that this member society also they have involved, Lordship, and they are mutually settled about themselves. So it is,
And in case of my lord, in the case of Vinod Dao case, honorable apex court of past judgment, where there is financial involvement, so that matter can be,
What,
yes, ma'am.
Which paragraph?
My lord, this very voluminous judgment. Let us,
Not your relevant paragraph, not the submission of the advocate, but the
yes.
observation of the Honorable Supreme Court.
my lord.
Which
The
paragraph?
operative portion, yes. My lord, page number 67, my lord, page number below, down below page number 67, my lord.
Page 67.
Yes, my lord, page number 67, para number 16, inherent power of. Page 67, page number is down below, my lord. 67.
Yes, para?
Yes, my lord, para 61. Inherent power
Yeah.
is of wide plenitude with the statutory,
No, but this is an observation of.
yes, observation
of the
number.
Supreme
So
Court
in this case.
Gyan Singh, Gyan
Yes,
Singh.
my lord. In this case, honorable apex court has taken reference of the various Rajesh Sharma and then the Rajesh Sharma case and then Lalita Kumari case. Important judgment is reference in this case.
So which part
My lord, here
regarding financial?
here, my lord, the honorable apex court observed that the type of cases which has to be crossed by the honorable high courts, it mentioned clearly.
Financial, commercial, mercantile,
Yes,
civil.
yes.
Para 61.
Yes, ma'am.
Actually, this is not para 61. This is para
This-
38.
It's download from the website, my lord, so that's why para number is not clearly.
38.
So in regard to that, my lord, other shareholders, they have even concerned that they have no any objections.
Mr.
And Raman.
We both club together both the orders. No. Only the appeal, main appeal. Mr. Criminal petition number, only criminal petition number. Item number
5, 6, 4 and 5.
4 and 5.
Yes, my lord.
Okay, the IA is 4 and, okay, only item number 5. Only item number 5. Heard Mr.
N. Raman.
N. Rama, the counsel for the petitioner. Joint petition,
Yes, my lord. Joint petition,
husband and wife.
husband and
So
wife.
we can mention the names of husband and wife in
Yes,
this case,
yes.
because this is not regarding family dispute.
Yes, yes.
Learned counsel for a petitioner number 1 and 2, not necessary, names not necessary. Who have jointly filed a petition under section 482 CRPC, an application under section 482 CRPC with prayer for quashing the FIR dated 13/4/2017 registered as Nahalagon PS case number so and so under so and so sections and subsequent proceeding of the case. And also for quashing the charge sheet number 113/2017. The petitioners are spouses and they have jointly filed this petition. As they have amicably settled their dispute, the petitioner has also appended the deed of agreement as annexure,
My lord,
C
annexure
series.
C series.
annexure C series. Art Miss Akhil Lakshmi, granted additional PP for the state of Arunachal Pradesh. The allegation against the petitioner number 1 was that he misappropriated an amount of rupees 4,90,000.
4 lakhs, only 4 lakhs, my lord.
Amount misappropriated an amount of rupees 4 lakhs meant for the Abu Ani
Abu Ane Multi-Purpose Cooperative Society.
Cooperative Society Limited. Stop. The informant was she was a chairperson.
She was the informant, the wife, my wife, and chairman of the society.
The informant was the chairman of the society. Who stop. Both the petitioner and the informant, who as spouses have gone separate ways. Who stop. Their marriage had been dissolved by
No, no.
decree of divorce.
No, no,
Not
no.
at all. The petitioners are estranged spouses and they are staying separately. The process of divorce is under.
No, no, my lord,
No.
earlier they both were
they
living
are staying
separately, but
separately.
now they are joined together, yes, as a spouse.
Oh. Although they are not estranged now.
No, 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 they are living together.
The petitioners who were staying, the petitioners have gone separate ways and estranged. Strike out the sentence. Both the petitioners had a family dispute and they were staying separately, but now they have restarted their conjugal life and they are staying together. And I numbered as IA criminal 16 within bracket AP 2023 was filed by the petitioner. And annexure A appended to the IA is a certificate by the chairman and the members of the Abu Ani Multi-Purpose Cooperative Society, certifying that the petitioner number 1 has returned rupees 4,49,000 to the society. The learned counsel for the petitioners has submitted to quash the FIR as the FIR has become infructuous. The allegation has become nugatory.
The lordship is also submitted that during the trial also, there's a blink chances of conviction, lordship. There are blink chances of conviction.
All right. This is a as all the members of the society, including the chairman, has no grievance against the petitioner, probability of conviction appears to be remote and bleak. I have also considered the submission. I have also considered the annexure C series, which is the deed of execution, deed of agreement executed between the which page, annexure C series,
My lord,
which page, annexure C series,
my lord, 82,
page 82.
yes, operative, my lord, in deed of agreement. Page number 81, starting from page number 81 to 83. Sorry, 84.
I have also considered deed of agreement executed between the petitioner as well as the corporate society. Which clearly reveals the mode of settlement between the petitioner number one with the cooperative society. The petitioners have also relied on the decision of the Honorable Supreme Court in Binod Dua versus Union of India in connection with writ petition criminal number 154 of 2020 decided on
Decided on my lord, 3 June 2021. Decided
3
on
June
3 June 2021.
2021. This person passed away, no?
Yes.
He
yes.
died.
Oh,
He
yes,
not do, he's no more.
oh. He was a journalist, my lord.
Yeah, very famous journalist. Wherein it has been observed that para 38,
Yes.
page 68 and page 66 and 67. Entire para 38. Reverting back to this entire para 38, no? Page 60, including 61. Including 61, you will understand. I have given double tick with pencil. Page 66 and 67, beginning and ending. Page 66 and 67 of the judgment. Reverting back to this case, it is also held that the petitioners were embroiled in a financial dispute. The money allegedly misappropriated by the petitioner petition number one has been returned back to the society. Full stop. I would also like to reiterate that there is no probability of conviction. In view of my following discussions, petition is allowed and the FIR number so and so, charge sheet number so and so, and further proceedings against the petitioner number one is quashed in such a site.
Highly obliged, my lord.
In view of the observations made in the criminal petition number so and so, this IA is disposed of. That much will be sufficient. Not interested, I think. Not interested.
Conducting counsel is in.
Oh,
Order number
another
one.
code. We'll wait, no problem.
My lord,
Hmm.
they pass over.
Passover, all right, Passover, after 1 week,
No, after,
time beings.
yeah, after 10-20 minutes.
Oh, Passover for the time, okay.
Yesterday I have taken steps to the private respondent in this case. Matter maybe.
This one,
Yes, I can.
Civil Appeal 1 of 2021,
Yes,
you have taken steps
yes,
yesterday.
yesterday. That means
You are
I have
appealing?
I have initiated the process.
You are the appellant,
Yes, I'm.
Maybe adjourn and
Learned counsel for the appellant, Mr. Tapak has submitted the steps have been taken to issue
Yes, sir.
notice to
Yes.
respondent number two.
I think it is two. Respondent number two.
Respondent number two, service report is awaited. List the matter. When do you want?
After 3 weeks. After 3, it is passing it will take time.
For 3 weeks.
3 weeks.
So
That may be.
meanwhile, can we call for the LCR?
Joseph, as a paper box also
Yes,
ready,
paper box.
Joseph.
Already
It's ready.
Yes.
It's already admitted, which implies.
Yeah, please. Here, Millard, I am appearing for the respondent number 3.
Petitioner is not interested.
Here, Millard, last order, I have to file the affidavit.
Have you filed?
Division make it. So. Will
Make it.
make it, will based on the LCR,
Hmm? Hmm.
based on the LCR. Not much required to file it.
Not required to, yes,
Yeah.
make it, not required to file.
Therefore, Millard, this case maybe fixed for final, part 2 hearing.
We'll admit it,
Yes, sure.
can be admitted.
I pray for
So do we have the LCR and anything? No. we'll call for
LCR, I
the
think
LCR now.
LCR,
We'll call for the LCR after admitting it. Has it been admitted?
it was called for, but whether it has come to the court or not, I don't know.
Listed with the LCR.
With LCR.
Reflected in it.
Then we can argue the matter if LCR is available before this court.
No, no. We are fixing it for hearing. It's not bad, not good to argue. Appeal. It's an appeal. We should fix it for hearing.
Of course, appeal, but if everything is ready, we can argue the matter.
We'll fix the
I don't
part 2
know.
hearing.
Are you in a hurry? You are the complainant.
Yeah, I am claiming.
You're the claimant, yes.
This is very old case.
I know. So we'll hear it then. Are you ready for the hearing?
I'm not ready.
So then we will fix it for hearing.
Yes.
But you have to be ready because the claimant is suffering. You have given him some money, 20%, 25%,
No,
or you, have you?
only no fault liability of 50,000 was paid.
Only. So compensation also, 25% of the compensation is also not paid. So you have to be ready with the argument within a short period of time.
Yeah. In this case, before the trial court, respondent number 1 and 2 was not contested. Only I'm the
Insurance,
insurance company.
others will not
So here also
contest.
they are the parties, but the state,
Usually they
One
won't contest. Have you taken steps against the other respondents? They won't contest.
They did not contest in the court below.
In
So
the
they-
original case also. they
Yes,
did not
yes,
contest.
before the tribunal. So they
So
will not
this,
contest.
Do you want to file counter affidavit? No, do not want to file. Not necessarily, not
yes,
required.
not necessary, and based on that.
Okay. Hard learned counsel, Mr. Learned counsel, Mr.
Yes, Koyam.
S. I don't know which one. is it? 9, no. S. Koyang for the appellant and learned counsel, Mr.
Embodied.
M. Bose for the respondent.
No.
This is the matter for hearing positively, okay, on short date of the hearing.
MP.
26.
It was earlier admitted, I believe so,
Hmm.
because LCR has already been called.
That has been called. 26.
I'll admit it then,
All
just not admitted.
Kindly admit.
I'll admit it, definitely. This, oh, yes, it was admitted. Admitted. This is the matter for hearing possibly.
26. 27.
All right.
My lordship,
Hmm.
lordship, service against private respondent is still awaited, lordship.
Hmm?
Service against private respondent is still awaited, lordship.
Awaited?
Lordship.
Heard Mr.
K. Lolen, lordship.
K. Lolen,
Lordship.
learned counsel for the appellant, list of service against the private respondent is awaited. Heard Miss. Yes, heard Mr. D. Sarin. Learned public prosecutor for the state of Arunachal Pradesh. This is the matter,
3 weeks, Lord. 3 weeks
3 weeks.
of license.
My pleasure, Lord. Here, step has been completed.
Mm.
So this morning, respondent number two's acknowledgement card has been received by this in the bench.
Registry.
Yes, one is already received.
Ah.
So step is completed.
AD card returned back to this ST after causing duly service of notice in respect of respondent number 1 and services awaiting respondent number 2. So respondent number 2 also complete service.
Completed,
You know,
yes.
it is not mentioned, but this is the order of 17th.
Yes,
So today morning they have received.
yes, yes,
According to you.
yes.
Had Mr. D. Bose,
Yes,
learned counsel for the appellant, who has submitted that service report on respondent number 2 is complete.
completed,
The office note dated 17/7/23 indicates that service report on respondent number 1 is complete, has been received back after service. You will list it for in the admission column then.
yes,
Are you sure, no? You are sure.
yes, this morning,
The admission column list the matter for admission on
let's say after 2 weeks, if it is fixed,
after
After
2 weeks.
2 weeks. In the meantime, let's say there is an interim order,
Interim order.
interim may be contained.
Enforced till then.
Highly obliged.
Afternoon ले लो. Afternoon ले लो. आना है मुझे.
Wait, please, Your Lordship. It's a 482 application, my lord, for quashing of the charge sheet and FIR, my lord, and order framing charge. My lord, the incident so happened, my lord, that the informed. My lord, I am for the petitioner and sole respondent, I think they are appearing today for the first time.
For the first time. Okay. So we'll fix it for admission then. File affidavit. Alright, Mr.
HK Jamu,
H.K. Jamo, learned counsel for the
petitioner.
petitioner and Miss A. Parme, learned counsel for the respondent, sole respondent, one respondent.
Yes.
Post of the learned counsel for the respondent has paid for time to file affidavit in opposition. Affidavit in opposition, post of prayer is allowed, list the matter on,
There's an interim order.
okay. When do you want listed? List the matter after 3 weeks, interim order shall continue till then.
Obliged.
In this case, the office note shows that the service report is awaited.
Hmm. All the respondents.
Two
Respondents. One is the firm
and the two is the proprietor.
So.
My learned friend has
complete,
appeared, I may come up after 6
after,
weeks.
For
for
admission
admission.
then, heard Mr.
BK Singh.
B.K. Singh, learned counsel for the petitioner, and Mr. R. Koyu. So you have appeared for the first time, no?
Yes, actually,
How these names have appeared? In the causeway, some advocate's name has been reflected, but in the office note, it says that, yes.
That's what you were saying, that's why I was wondering why. this-
Even I haven't filed the Wakalatnama because the respondent is in Delhi
Oh,
undergoing treatment.
oh,
I'll be filing Wakalatnama in the meantime. once the,
so who has appeared on behalf of the respondent number 1 and 2?
1 and 2.
Two respondents only. Matter may come up for hearing on the next date, matter may come up for admission,
Admission
on the next date, list the matter on
after 6 weeks.
after 6 weeks.
Obligement.
Oh.
May I please, madam?
Oh.
Madam, this is a bail application,
Hmm.
madam. Successive bail application, madam. Basically on the ground, my lord, on the ground of parity, my lord.
Oh.
Because co-accused has been granted bail by the special court, the trial court, my lord.
It is not present. Oh,
No, it is not. Yes.
Pass by all it with you. Not interested maybe. Or should I, this is for orders. So
No,
I
sir.
can fix it for admission.
No, sir.
Let me see the office
The
note.
LCR was called for, I can copy of the LCR, whether it has received.
Can copy of the received.
Received.
So LCR is received. So what about respondent not appeal?
No, because it's joint petition lawsuit.
Joint petition.
Yes,
okay.
no,
So we'll fix it for admission.
Lawsuit.
LCR is received. Heard Miss Halki Lakshmi, learner and additional PP for the state of Arunachal Pradesh. This is the matter for admission. This is for order, so we'll list it for admission.
Lawsuit. After lawsuit, please after.
After 2 weeks or 1 week, not interested in 2 weeks.
2 weeks. lawsuit. Okay.
I'd like to see. This is hearing, item number 19.
Lawsuit, the petitioner, consular petitioner is absent today, lawsuit.
Oh,
His junior, he spoke to me that, the sir will appear after 2 weeks, so
okay,
they will
okay.
want to take time
Learned
for 2
counsel,
weeks.
Mr. N. Ratan is out of station.
This is not appear today.
Is
lawsuit,
not
maybe.
present today. Heard Miss Hakim Lakshmi, learner addition PP for the state of Assam. This is the matter after 2 weeks for hearing.
Lawsuit.
It will go item number 19.
Like,
This is a pre-arrest bail application filed by the applicant. Here, some allegation was made against the applicant that she has used and forced the signature of the complainant and executed a deed by of his land allotment documents. That was the allegation, but here the applicant and the complainant are not known to each other. If lordship permit, may I read the FIR?
Yes.
Page number 15 here. To the officer in charge, Police Station, Nahalagan, District Papumpare, AP. FIR dated 13/7/23. FIR against Srimati Yagum Kabak, daughter of late Kabak. Thakur.
Page number?
Page number 15, your lordship. Page number 15. Resident of C2 sector, POPS Itanagar, District Papumpare, for fraudulently using my land allotment bearing number 12-010-08 dated 15-10-2008 and forged my signature. This, sir, in the context of above mentioned subject, I would like to inform you that one, namely Srimati Yagum Kabak, daughter of late Kabak Tajuk, who fraudulently using my land allotment bearing allotment number 12010008 dated 15-10-2008 and also receive a amounting of rupees 50 lakhs only in my name without my knowledge and consent. Moreover, by reliable sources, it is came to know that the prepared give deed agreement against my allotted resident plot by Nalagarh, the allotment number dated so and so, located Prem Nagar B.
Yes, yes.
This is the allegation that, and here it has also said that whereas she is completely stranger for me. I have never ever met her personally. That same is with the applicant also. She never met that person. Brief fact of the case is that, Your Lordship, in the year 2022, one Jinta Cherry, a lady who was known to the applicant, she came with the allotment copy of the complainant, which is not known to the applicant, and approached her that person need a complainant need a loan amounting to rupees 50 lakhs. So he wants to keep his land allotment as security, as applicant used to lend money to in interest basis, or she managed those money from some other person and to lend. So this lady and the applicant were known to each other since for last 4 or 5 years. As this lady, Srimati Jinta Cherry, was doing a business of local ornaments, local beads and ornaments of Arunachal, local ornaments. So they were known to each other. She came and said, elder sister, and approached her that this is my relative, so I need loan. In good faith, she approached one Biswadar, who was a renowned businessman from Dibrugarh, Assam. And the applicant, they know each other because they have done lots of contract works together in Arunachal together. So she took her and approached that Biswadar. The Biswadar was ready to lend the money, but he kept a condition that there should be a execution of the deed agreement between and that should be done by the applicant. And then only he is going to lend the loan amount. After there was some discussion going on. After that, later when Biswadar transferred the money in the account of the applicant, then after that, due to some reason that money could not be lended loan to that person, Srimati Jinta Cherry. She was supposed to receive that amount, and she said that she will execute an agreement, and she have placed one document land allotment of that complainant, that is Tana Chika, which is unknown to the applicant. On his behalf, she is going to receive the amount, but due to some misunderstanding, that execution could not take place. After that, the money was with the applicant. Then applicant have informed the Biswadar, the person who have lended money in the hand of the applicant. Then applicant inform and applicant have informed the Biswadar that the agreement and execution could not be take place. So this amount, I'm going to take loan from you on the basis at the rate of 5% interest. Then that money was taken by the applicant and the interest was paid to the Biswadar. So here applicant is undergoing treatment, so I could not produce before Honorable Court the bank statement, which I'll produce before the CD court. So here after this complaint was lodged, was unaware to the applicant.
So bank statement, and how can I grant you interim relief?
Yeah, Lordship, I am praying that Lordship may.
I'll call for the CD then.
Your
Yes,
Lordship, here is the.
Let us
Otherwise
call for
also
the
the
CD.
the
At
allegations
least
are
where
very,
your bank statement was necessary.
yes.
Your
Let us
Lordship,
call-
Lordship, my prayer is that she is a lady. She is going under treatment at Delhi, your lordship, I have mentioned in the paragraph, and there is latest
So
now.
nobody arrested from Delhi, yeah?
Yes.
No, your lordship, now she is there here, your lordship. I'll take lordship, give me some few minutes of time. I'll not make it lengthy.
So I'll come back
Yeah.
and I will complete. I'll come back
After
here.
that. Yes,
After
yes,
break, I'll come.
yes,
back.
yes.
I'll
You
give
know, I
an
pray your
order.
lordship to listen.
You want interim order?
Yes, for she's now also
The
under.
Bank statement, you should have given me the bank statement. So I'll
Your
come back.
lordship, here is the medical prescription latest. Now she is being advised by the doctor to take complete 1 week bed rest. She is a
Anyone
acute
in the
severe.
hospital, there is a, your lordship is well aware, the police won't
lordship,
arrest
after-
anyone who
after
is
lunch break,
admitted
your
in the
lordship.
hospital.
Pull her out of the hospital,
Never.
that too early.
Yes.
Your lordship, after the lunch break, lordship.
Let me see, I'll come back after the break.
Right.
How far you can convince me?
Yes, lordship, I'll try my best, your lordship. Today might be my good day, your lordship, if I succeed. Yeah.
After the break.
Yes, your lordship.
Yeah, she's not well. Let me hear her
Okay,
of the
Your
story.
lordship, I would like to draw your lordship attention that she is currently undergoing medical checkup, which I have annexed in my annexure to page number 16. And here doctor have advised her to take complete 1 week rest. And in meantime, the informant and the LS accused person applicant are having talks is going on.
Talk of compromise.
This is only due to
Let me
misunderstanding.
hear the possibility.
So I pray, my limited prayer is that your lordship for few days till CD return back. Interim may be given that applicant is a lady and is a ill person. When she got the information by the informant that after that she immediately rushed from Delhi. She was at Safdarjung, New Delhi at Aslok Hospital going gastrointestinal checkup. She was admitted in the medical, but after listening that news and by the informant that she immediately rushed from Delhi and again returning back here. She's again now ill. So I pray that till CD is returned, I may be given interim protection because I am also a government employee. I'm working as a upper division clerk in the office of Deputy Commissioner, Capital Complex, Itanagar. So there is no any chance of.
Last week order has come out now from Supreme Court that MP is not to be granted bail even if he is to contest the election.
No.
So now this type of government employee.
But I pray that your lordship says he will
Let me hear the
cooperate.
prosecutor, what she has to say. We'll consider your prayer.
Here, lordship.
I'm very
it is-
familiar with Dr. Sanjay.
It is written here that complete bed rest for 1 week, your lordship.
But it is regarding her son that.
No, but she went for some medical treatment and she fell ill over there. And that is, your lordship, I just got few hours back, so I have the prescription discharge of that. After getting information, she immediately rushed back. She is not well.
Talk of compromise is also going on.
Yes, they are also, because someone have. So for short death, your lord, interim may be given, your lordship.
Look at it.
He has a history of illness. Earlier also she was regularly undergoing treatment. And after returning back to Itanagar also, she again fell ill.
So now she is normal according to the report.
After returning back here, again she fell ill, so she's now again going medical treatment. That is the latest prescription. Yesterday she go for the medical checkup.
The prescription in green, your lordship, that has also been annexed. It seems that she has been admitted in the hospital, your lordship.
So I pray your
That was
lordship,
called for the CD.
yes, still CD, your lordship, interim maybe.
Monday.
So till that, she is now having intense in a depression and pressure that what going to happen her. So she is law abiding person. So say after getting the information, she came back, leaving the further medical course of treatment. So and in meantime, with the complainant, they are also having talk. So your lordship, till Monday, your lordship interim may be given, your lordship.
Lordship, since the matter is also from Naharlagan, your lordship, in that case, take the matter on Friday, your lordship.
This Friday.
This Friday.
Lordship, it will be better on 20. It
20
means,
is tomorrow.
not 20, on Monday, that is on 24th. Meantime, she will cooperate the IO. And if any amicable settlement reach out in between this week, then
No, there is nothing to settle with the informant. Informant's land has not been taken over.
no, neither
Only
anybody have
for-
causes, yes, only
Only
due to misunderstanding that why she
But she
has
has taken money from somebody else. third
somebody
party.
else, but not from the informant.
But the third party is not, has not lost any money.
So I pray
Let
you,
her be on interim bail.
Lordship may fix
Not
this
agree.
matter on. No, your lordship, because as I have already submitted, your lordship, if she is in a hospital, your lordship, there is no question of being arrested. However, your lordship, I leave it to the discretion of
till then there
this
is
honorable
event of
court.
arrest, your lordship, so.
If I may be allowed, your lordship, because if I am allowed to, your lordship, at least will come to a solution, your lordship. I leave it to your lordship's discretion that interim be granted or not. However, the offenses, your lordship, is, your lordship has rightly pointed out that using that allotment and by forging her signature, the amount of 50 lakhs was being taken, your lordship.
By another, from another person.
Yes, your lordship. Now, the FIR seems to be small, but then the offenses, your lordship, is severe in nature, your lordship. Till
So-
24th, your lordship, the city will, I leave the in terms
So,
of the
your
interim, I
lordship-
leave it to the discretion of.
So I pray your lordship to give interim because she is a woman. There is no chance of tampering, your lordship.
All right. I'll grant you interim bail and we'll call for the city. Third, Mr.
But sir,
A. Bhattacharjee. Learned counsel for the petitioner Yagum Kabak. The petitioner has filed an application under section 438 CRPC with prayer for PNS bail in connection with so and so PS case under so and so sections. Third, Ms. T. Ginny, learned additional PB for the state of Arunachal Pradesh. I have considered the submissions at the bar. The allegation against the petitioner is that, where is the FIR, page 15?
that is in page 15 there also.
That she fraudulently procured an amount of rupees 50 lakhs in the name of the informant against land allotment bearing allotment number NLG 12/010/08 dated 15/10/2008, which has been allotted to the informant full stop. The petitioner also prepared give deed agreement against this allotted plot of land in the name of the informant. Which has also been registered at the office of the DC Capital Region Itanagar. Full stop. An FIR was lodged by the informant which was registered as the present Nahalagan PS case number 111/2023. The learned additional PP has raised serious objection against the prayer for interim protection, stating that the petitioner is registered under a serious offense under section 409, 420, 423, 465, 467, 468, 471, 477 A IPC. It is submitted on behalf of the petitioner that she is undergoing treatment. Earlier, full stop, she underwent treatment at Delhi, and at present she is undergoing treatment. The medical documents are submitted. And annex S,
Unacceptable.
annexure 2. It is also submitted that the petitioner is a government employee. Full stop. A talk of compromise is going on between the petitioner and the informant.
Your lordship, if on that ground, your lordship, the apex court is clear that on the ground of
Talk of
there
compromise.
being any talk of compromise, that should not be a ground for bail, your lordship. If your lordship,
So that is just my submission. I have not.
uh,
Talk of
though-
compromise
though-
of giving money.
yeah, that submission may not be recorded in your lordship's order.
Yes, yes. Talk of compromise, strike it off. Better not to. We submitted that this case was initiated against the petitioner on misunderstanding. This will be better.
Yes,
than
Misunderstanding,
compromise.
because
yes.
complainant also doesn't know and applicant also doesn't know each other.
The petitioner and the applicants are cousins. Call for the CD, list the matter on
24th.
24. In the interim and in the event of the arrest, the petitioner shall be granted bail of rupees, shall be enlarged on bail of rupees 50,000 with a suitable surety of like amount to the satisfaction of the arresting authority under the condition that the petitioner will appear before the IO within 7 days and cooperate with the investigation.
No, your lordship, if your lordship is fixing the matter on 24th, your lordship. Since she is in the hospital, your lordship.
What about-
She was,
Your
just a second, she was admitted yesterday,
Hmm.
today is 19, 20, 21, 22,
1 week bed rest.
20, 21, 22, 23, 4 days,
Hmm.
within 4 days, then the matter is coming up, your lordship. By that time, if they are cooperating, your
appears,
lordship, yes, within 3 days, your lordship.
So we will postpone the date then.
26 your
For
lordship.
CD?
otherwise-
No, your lordship, in that case, your lordship may, in that case, give it condition that as soon as she is out of the hospital, discharged from the hospital, she
The
may.
petitioner will appear before the IO as soon as she is discharged from the hospital and cooperate with the investigation. Number 2, the petitioner will not tamper with the evidence. And number 3, the petitioner will not leave the jurisdiction of the court without prior permission till completion of investigation. All right.
Oh,
Deeply.
20.
Lordship, I think it is expertly hearing.
Expert hearing.
Yes, expert.
Oh,
I published, this is 2018 case. I have issued number of steps, second steps to the party. Also, I have published in the newspaper as per the direction of this honorable court. Matter is, I think, fixed for hearing.
All right, you can proceed.
Lordship, first of all, the issues to be settled with honorable court is that the petitioner is the present respondent has filed one money issue before the court below. Amount is 1 lakh, along with some interest as per this money receipt given in this copy. This money receipt is in the name of Munisi Police Fund. I have enclosed. So, against that, against the suit, I have filed an objection before the court below, saying that this case is defective because Munisi Police Fund is not a registered society. Neither he can sue or be sued. Number one. And they're saying that he has been authorized by the person who is the owner of the Munisi Police Fund. In this case, case can be filed as per the CPC when it is a registered society in the name of President Secretary or that the case can be filed in the name of that organization, in the name of that society. But when it is an unregistered society, unregistered entity, in that case, all the affected person has to file the case. All the affected person has to be a party. Even if
Which part of your petition have you mentioned it? In which paragraph of your petition?
kindly see page number 11, annexure 2. This is the impugn order. I'm mentioning the impugn order.
No, in this petition, which part of the petition you have filed? That all the parties were not impleaded, all the petitioners were not impleaded, as it is a non-registered society. Because without
Kindly see page number 3, page number 4, paragraph 3.
page number 4, paragraph 3.
Yes. The revision petitioner begs to submit that the dependent have filed their written statement denying that taking loan from the plaintiff. And raised preliminary objection to the maintainability of the suit on the ground that Munisi Police Fund is not a registered society under the Society Registration Act, which can be treated as legal person to sue or be sued. Moreover, Srimati Jorampuni, who is the plaintiff in the case, is not a police and is not a member of Munisi Police Fund. He is not a member of Munisi Police Fund. She doesn't have locus standi to file the money suit representing Munisi Police Fund. So he has not been authorized to institute the money suit either by the member of the Munisi Police Fund or by law. As such, the money suit was not maintainable in present form, but the landed civil judge, Senior Division Law 770 has arbitrarily not accepted the preliminary objection and prepared to proceed with the case by the organization. This is the impugn order in this case. So, what is the law when it is a unregistered society? That is, I am pleading law, pleading the part of law. What can be done? When it is a unregistered society, then each and every affected person who is the owner of that money, that has to be a party in that claim. That is the law. But in that case, it is not. The plaintiff has failed to show that this is the owner of the money. I have been authorized by that person. That is when the plaintiff is not an owner of the law. She has no locus standi to file that claim, that suit. That is why when the case is not maintainable in terms of law, the case cannot be possible. This is the simple argument before the London Trial Court. That is why while it's a passing order in favor of the.
So the society, Police Fund was a registered society.
Not the registered society. Not a registered society.
neither the plaintiff has failed to prove, neither has success to prove that it is a registered society, nor it is, they proved that all the plaintiffs, all those plaintiffs were the owner of the money reported for.
So this case is proceeding. Is
Not-
there a stay order?
Case is stayed.
Stay.
State. That is why, while passing this impugn order, the section 65 of the Contract Act
Hmm.
has been relied by the landed court.
Hmm.
Section 65. What section 65 indicates, signifies? As per the section 65 of the Indian Contract Act, what they say, obligations of the person who has received advantage under void agreement or contract that becomes void. That is the language of the section 65. That means my contention before the trial court was that I have not received any money from the plaintiff. Because the plaintiff is neither belong from any illicit fund, and he is paid to show that he is the affected person.
So according to you, does not apply.
They didn't apply because section 65 doesn't apply in this case. Because money doesn't belong to the plaintiff. When the money doesn't belong to the plaintiff, section 65 doesn't apply. To attract this section, the plaintiff is to show that money belongs to him, but the agreement was void. That is not the case. That is why in these two aspects, there is a insufficient ground to proceed the case further. That is why I filed this revision petition for setting aside of that part of proceeding of the case. That's all.
All right. Our argument by Mr. T. Tapak or Tayak?
T.
T. Tapak, reserved for judgment and order.
In support of this, my case.
You have mentioned the paragraphs,
Yes,
relevant paragraphs,
24 and 25 and 26, I think.
para 25 and 26.
25.
You have highlighted,
I like it.
it was very good. Reserved for judgment and order.
Right.
Yes, next. 23.
It's a criminal appeal, man. It's against the, my lord, impugn
Conviction,
conviction. 376.
376.
My
All right.
lord, sure.